24 to enable political parties to upload all the required information. I'm of the view that Operation Dudula has itself to blame. It left everything to the 11th hour. I'm mindful about Operation Dudula's asserted political rights enshrined in Section 19 of the Bill of Rights. However, rights go hand in hand with responsibilities. Operation Dudula has a responsibility to ensure that it complied with the set rules to enable it to contest the National Assembly elections. And we submit the same principle should apply in this matter. Thank you, Deputy Chief Justice.
Any reply, gentlemen? Mr. Loxton?
Thank you. Very briefly. First of all, as regards the insistence by the Commission that they should apply the law strictly and that is what ensures free and fair elections and that they shouldn't change things ad hoc, they're not really consistent. They changed the law, well, they ignored the law relating to the physical or the online uploading of signatures for supporters. And recently I see there's a notice given by the Commission that they extended the timeline for the application for special votes on the 3rd of May from 5 p.m. to 12 p.m. to midnight. So they're not exactly consistent in that way. It's important that we get the 65-35% issue right. The learned friend has said it's not, that they haven't said that the 35 could not comply with requirements because they could not upload information to the portal. But in fact, that was the question that they answered. If you look at their letter, you will see that they say they're going to answer the question. And when you look at the answering affidavit at paragraph 108, you'll see they say they have answered that question. In other words, we must interpret the answer as being an answer that 35% of those that attempted to upload the relevant information failed to do so by the timeline. Now, one of the important questions here is what is fit for purpose? Because the learned friend has phrased the question. He says, you've got to look at the probable consequences of being unable to exercise the right, even if one acts reasonably. If the probable consequences are that you will be excluded from participation in the election, then there's a breach of Section 19 that flows from that. So the question is, how do you apply the test in this particular case? If the Commission had said they had designed a system, electronic system, for uploading information, and they are happy and proud to announce that when it operates, they estimate that at least 65% of people will be successful, there would have been outrage. There would have been an outcry. So what is the answer to those percentages? They say, well, a couple of things. They say, first of all, your objections of the Labour Party's objection and other parties' objections is personal. It's not objective. That's not true. Everything is objective. If I'm driving a car and the brakes fail, and I observe that the brakes fail, that's an objective observation. It just happens to apply to me. So from that, you get to a situation where we say, what do we have on either side of the equation? And if you apply Plascon-Evans, if it is applicable, what's the result? On the one hand, the Commission says, look at my service provider, and you say, yes, all right, but it's unlikely that that's correct because you yourself admit to complaints which are genuine, they're not dishonest, of the system hanging, of being kicked out and the rest. So you can't take that at face value. Secondly, they say, well, look at what other people have managed to do. But that's an irrational approach. If A manages to comply and B doesn't, you can't say that it's the system or it's A or it's B. But if 35% do not manage to comply, then unless you're dealing with a cohort which is particularly backward, then it's only explicable by the fact that the system is not working as it should for the people for whom it was designed. And the impression that one gets when one listens to what my learned friend has had to say is that the IEC has constructed a survival course. And on that survival course, there are many obstacles. Some will survive, some will overcome the obstacles, some will not. 65% will actually get to the end of this course. 35% will not. Is that satisfactory? Is that what this court will finally say, knowing those statistics, knowing those facts, we find that there's been no deprivation of the right to vote, the right to put up a candidate. That's okay. The IEC, the Commission, has done its job. No one should feel done down. No one should complain. And we say that that can't be right. And it can't be right to deny access to this court by saying, well, you've applied for direct access, but actually you should have appealed. And if you had appealed, we would have said to you, but we're stuck with the facts that were found, that the Electoral Court found, and that were before it and its findings, so you're going to fail on appeal. So if you come direct access, you fail because it's direct. If you come by appeal, you fail because of the facts before the Electoral Court. So what you're really saying to these parties is there is no road ahead for you. Sorry, you didn't make it. You didn't complete the course. Go home. Try another day. That's not a satisfactory outcome. And we say that even if you apply the Plaskon-Evans rule, because the Commission is unable to say to any of these parties, the Labour Party included, you did not experience the problems that you did, it cannot rely on Plaskon-Evans to say to this court, accept our version. Unfortunately, there are a great number of people who couldn't comply, but it is the survival of the fittest. Let the fittest continue. Those who are not fit enough, too bad. That's not a right outcome. Thank you.
Thank you, Mr. Loxton. Mr. M? Sorry. Any question? It's been a long day. Sorry, everyone. Any questions, colleagues, for Mr. Loxton?
Sorry.
I'm sorry. And you're so quick to sit down.
On the short reply. It's home time.
No questions for you, luckily.
Thank you.
Thank you very much. My learned friend for the Commission adopts a Delphic approach to the rules of evidence. What he says is, Plaskon-Evans applies, and you must decide on what we say. But at the same time, the rules of evidence are thrown out the window because what we'll do is we'll file substantive affidavits on appeal to make out the case, to render what was inadmissible before the Electoral Court, and to try and render it admissible before this court. What's good for the goose has got to be good for the gander. It can't operate both ways. But we submit the difficulty that my client faces is that it's now placed in a position where this court, with respect, over and above the Sophie's choice you've got to make about if we are to succeed, about what's to happen. But my client's case gets contaminated with evidence that is relevant in another appeal, being the report of the IT experts. That evidence, and my learned friend hasn't for a moment suggested that it was admissible in the Electoral Court. And this all turns on whether there is a genuine dispute of fact. Because at its high point, the case made for the Commission in on the dispute of fact is, well, we've got these expert reports. Well, they're inadmissible and they're irrelevant. And they weren't before the Electoral Court. And 65% or whatever number managed to do it. So from that, we draw an inference. But we set out in our heads the circumstances when it's appropriate to draw an inference. An inference can only be drawn when sustained by the proven facts. And the Commission puts up no admissible evidence to justify the drawing of that inference. And in any event, as my learned colleagues point out to me, Section 19 is a subjective right. It's a right that is available to every individual, and not most people, not 65% or 35%. So we submit in this application, there is no admissible evidence, there is no appropriate inference to be drawn that justifies the existence of a genuine dispute of fact. Now, my learned friend says rules must be enforced. We agree rules must be enforced. He says deadlines matter. We agree deadlines matter. But so does the system you create, which you seek to rely on for the enforcement of the rules and for the enforcement of the deadlines. I don't know if the Commission's sensitive about its system, because it definitely adopts that attitude in its papers. This is not a blame game. It's not about whether or not the system was designed with the best intentions, because he focuses on design and not so much on functionality in his arguments. It's about whether the system failed or not. And the system may have failed for various reasons, completely unrelated to the Commission. But the objective fact is that the system failed. So it's not about who's to blame. It's not about who's responsible for the system. And that objective fact creates the objective impossibility for my clients to have complied. My learned friend made an incorrect submission, and it's part of the problem when you roll all of these cases together, because the facts in one case contaminate the facts in another case. He says that my client, only complains about the system on the 7th or the 8th. That's not correct. If I can ask you to have regard to the founding affidavit in the application before the Electoral Court, page 17, paragraph 20.5. And I'm going to read this also within the context, if you can maybe put a mental flag there, as to what a reasonable party would do, because that's my learned friend's argument. What would a reasonable party do? The founding affidavit, 20.15. On 20 February 2024, ACT sought and attempted access to the IEC online portal, but it was only able to do so on 21 February 2024. And we, my team and I, commenced the onerous task of first uploading ACT supporters list. This process was frustrated and delayed because of the defects and non-functionality of the IEC online portal. Despite these challenges, and as far as I can recall, ACT concluded the submission of its supporters list on 8 March 2024 in respect of the Eastern Cape. It had submitted its supporter list for the other 5 provinces and nationally by the 6th of March 2024. So, it's not true that it's suddenly convenient, because I submit that that's the inference my learned friend would want to be drawn, that it's convenient that we only complain on the 8th when it really matters. That's not the case. We always complain, but we did what we could. Now, he beats a drum about what a reasonable political party would do. I want to ask you, because we deal with it in our heads of argument, we set out a list. And it's again going back to those common cause facts about what my client did in order to be able to submit its lists timeously before the deadline. And that is at page 8 of our heads of argument. We started on the 21st. We secured a venue in the middle of Sandton, a venue that had stable internet access and high speed. We hand-selected 20 individuals who were suitably skilled. All of them had their own individual laptops. All the laptops were new and recently purchased. There was a 20-person team that was managed by 4 individuals who used the access code, so there were 4 users. Working hours in most days ran from 13 to 15 hours, starting at 9 o'clock and often ending past midnight. Now, isn't that what a reasonable party would do in order to meet the deadline? It's not submitted, my learner friend doesn't submit that my client was unreasonable. It just said it left it too late. But that's with respect like looking at a mountain through a straw. All you see is what you see through the straw. If you take away the straw and you look at the entire mountain, you will see that from the 21st, my client acted reasonably. And it cannot be said that my client left it to the last minute, because the Commission's case is that it would only take an hour or 2. And my client had that hour or 2 and it couldn't submit. So, turning then very quickly to Plascon Evans. There is no dispute. You can't be free and easy with the laws of evidence in this court on an appeal simply because the evidence is relevant to another matter. It's not admissible here. And then dealing with the relief. This court, if the court is inclined to agree that the system failed and that the failure of that system resulted in my client's inability to complete its list, then there's obviously a Sophie's choice. But with respect, you can't allow the election to continue when you know in your hearts of hearts it's not free and fair. Because there are 121,000 supporters of my client's political party who are now precluded from voting for reasons entirely beyond their control. There are 470 candidates from my client's political party who deserve to be on the ballot and are not going to be there for reasons entirely beyond their control. Thank you.
Thank you, Mr. M. Questions, colleagues?
Mr. M?
Yes, Justice Matopo.
Just a practical
I beg your
approach.
pardon?
Just a practical approach. Is it possible that your clients can be successful in these proceedings, the other 2 parties not? And is it also possible that the Labour Party can be successful, your client, and the other party unsuccessful? The Labour Party's case, as you heard, has rolled away from the disputed facts in the Electoral Court. You have sought to address it head on to say none of it exists, and if there is, it should be construed in favor of your client. So what I want to establish that, can this court be in the position to say, you are successful, they are not, or they are successful, you are not, or vice versa? All the permutations.
No, I appreciate the question and thank you. It's to a large extent, I can't take my submissions further than those submissions I made in response to His Lordship Justice Majid's question. What you can't do with respect is preclude my client, who's exercised all of their rights, gone to the Electoral Court, lost 3-2, come to this court, and non-suit my client just because there are other people who didn't exercise their rights, or because their cases weren't as good as mine. I would hope, and I certainly don't say that facetiously at all, that each matter will be decided on its individual merits. And if a party hasn't made out a case for, I'm talking within the context of the parties here, not broadly in this 35-65%. If there's a party here that hasn't made out a case for the relief it seeks, it shouldn't get the relief. If my client hasn't made out a case for the relief it seeks, then it shouldn't get the relief. If Mr. Loxton's case, the client has, then he's entitled to the relief.
Well, let me try and understand it. At the heart of all these 3 applications is the fact that the system did not function. If you are to succeed, we have to make that finding. And if they are to succeed, we also must arrive at that finding.
Well, as my learned friend quite eloquently set out, or my learned colleagues in their heads of argument, there really are two factual issues. The first is, did the system malfunction? The second is, did the malfunctioning of the system result in the inability to comply with the item 9 deadline? So I submit that it's not merely was the system malfunctioning or not fit for purpose. What was the consequence upon that? It may have been that parties who didn't even try the submission process, I don't know on what basis those parties get to benefit from a malfunctioning system.
Mr. M, let's forget about the parties who are outside and confine ourselves to the parties before us.
Yes.
Because we know what their cases are all about. We know what they need to do to sustain their appeals or not.
Justice Matopo, it will have to be decided on an individual case-by-case basis, the facts of each party. I can't submit that it becomes, because one party gets through the gate, that automatically allows the other parties.
I'm just worried about assuming you are successful. The foundation of your case is more or less the same foundation as the other people's case, other parties' case.
Yes.
And you produce a judgment that is in conflict with each other. You can find you're successful, the other two parties are not successful, and how do you reconcile the two judgments? I'm just worried about this court go in that direction. I hope you appreciate my point.
No, I completely appreciate your point. If I can give a practical answer. If Mr. Loxton's client was to succeed, and the result of that success would be the postponement of the elections, and I don't know why the interests of justice would preclude those parties who had similar complaints and exercised their rights from being allowed through that same gate, from a practical perspective. But that's obviously dependent upon the worst case scenario. As to the specific facts, I submit that there must be a fact-specific determination on those two questions. I'm sorry, I can't give a better answer than that.
Thanks.
I tried my best, but thank you very much.
Mr. M, this side.
Yes, Justice Mhlanga.
Yes. I will, for convenience, refer to the evidence that that is before the Electoral Court, that sought to address the question whether, that is from the IEC side, whether there were any problems at all with the system. Let me just loosely call it expert evidence in quotation marks, yeah. I want to know what differences in substance, not detail, there are between that quote-unquote expert evidence and the expert evidence that has been tendered before us.
Well, there are three fundamental differences. The first is that all that was put up before the Electoral Court were reports. That's the first difference. Not confirmed under oath, not explained. And we took issue with that. They're unexplained and they're not confirmed under oath. But as we read them, they're irrelevant because it's not about whether the system was live. That's the first question. The second issue is that the report that is now put up is more comprehensive than that report, firstly. That's before the Electoral Commission. And secondly, it's not just a matter of the affidavit being a confirmatory affidavit. If you consider that affidavit, it's a substantive affidavit in and of itself. And it provides the explanations of the report that weren't provided before the Electoral Commission. And the third thing is, my client is obviously prejudiced in circumstances where in these proceedings it doesn't have a right of reply, to deal with evidence which it took an issue with about being inadmissible and irrelevant in the Electoral Court, and now being presented with it. Really, it's a collateral challenge through the side door because it's in the Labour Party matter. So I submit that those are three vital considerations that need to be kept in mind, whether considering the admissibility or the impact of that evidence within the four corners of my client's case.
Thank you.
Thank you.
Thank you, Mr. Ram.
Thank you very much, and thank you for the hearing.
Mr. Ramait.
Thank you, Deputy Chief Justice Maya. Vilagazi, I'll be standing in for Mr. Ramaidi in respect of a reply. Justices, I'm not going to take up much of your time. I get the feeling that this court may be slightly confused in terms of what exactly our case was. The Commission has come here and said that we did not upload a list in time. However, Deputy Chief Justice Maya, you indicated that we had uploaded a list at 16:59.59. And by virtue of that, that is before 5 p.m. of the cutoff time. If I can just refer you as well to the bundle, please, where this issue of us not having a list is actually put to bed. Page 255 at paragraph 11, please, which is the answer of the Commission. And I just wish to read that into the record. Paragraph 111, page 255. It says, I admit that for some regions, it uploaded the requisite supporter information and signatures. But for the only region for which it nominated a candidate, Free State, it did not upload any supporters' signatures. Now, all of a sudden, the game has changed because there is confirmation that a list was uploaded. And I think it was Justice Majid who indicated in the Liberal Party case that Section 28 does not come to our rescue. And he says that in that Liberal Party case, the court had said it is to rectify other failures. However, the starting point of that case was that there was no list at all. So now it is for this court then to tell us, as the applicants, as well as the general public at large, whether a failure to upload signatures is equivalent to a failure to upload a list. Because if it is not, then what you have is you have a list, and what you have is non-compliance with what that case called rectify other failures. So then, in terms of Section 28, can the submission of signatures be rectified, and do they fall into other failures? So it's my submission, Justice, is that the Liberal Party case is actually different insofar as the words that were used by this court in explaining what that failure was versus the failure that we have here. The second thing is, if the cutoff time was at 5 p.m. and somebody submitted at 16:59, is that before cutoff? And I think you can only come to one logical conclusion, that it is before cutoff. And by virtue of that, there was then a list, and that list was the Free State. And because then we did not submit the signatures, that could have been rectified, which would have been, I think it was you, Deputy Chief Justice Mai, that asked when was that date of non-compliance. That would have been the 11th of March. Insofar as the relief is concerned, we are advised by the Commission that because there was no compliance, we did not successfully submit a list. But, pardon me, at page 101, which is, in fact, the candidate list in particular. I do apologize, I'm just trying to find it. That candidate list did show that at 1659-59 we had a submission, and then it showed again at 1700 we had another submission. Now, that document that the commission refers you to is problematic on two fronts. If it says that at 1659-59 our first candidate was captured, and then it says our last candidate was captured at 1700, immediately that implies that two candidates were captured. However, we are told that we only submitted one. Be that as it may, the bottom line is that there was a list that was actually then captured by the system. Insofar as the relief is concerned, the first question that this court needs to go to is ACDP ACDP case, where this court considered the issue of strict compliance versus substantial compliance. And I think at ACDP, there was no compliance because there was a failure to pay money. However, in this case, with the commission's own evidence, there is a list that has been supplied. So that, at the very least, ought to mean there was compliance with the requirements of Section 27. If, of course, then that this court finds then that there is compliance of some kind by the applicants, then opening of the portal is not beyond reason. Because had that happened on the 11th of March, then we wouldn't be here today as the applicant sitting in. Had the commission actually exercised the rights it is granted by Section 28, we wouldn't have come to this court. So justices, we submit that the relief that we are seeking is, in fact, achievable. And insofar as costs are concerned, I think I go with the rest of my colleagues, where I say, especially the applicants, that we are all here to protect our rights. And BioWatch, and I think Affordable Medicine has gone as far as to say that. We are not here for a frivolous matter. We are here for a matter that affects many disenfranchised people. I'm ready to take questions, justices. Thank you.
Mr. Vilakazi.
Yes, Justice Matupu.
Please help me to understand your case. Absent compliance with the IEC were the signatures only.
Indeed so.
Everything else, the names, particulars, everything that was required was on the portal system.
Indeed so, Chief Justice Matupu. Can I just refer you, please, if you don't mind?
My papers are in a mess.
Pardon me,
Which paragraph?
if I may, page 228
Okay.
of of the bundle, page 228. And in particular, I'm looking at paragraph 26.
26.
Now, that paragraph is headed in a deceiving manner because it uses the word AASD did not comply. However, if you go to that page, there is a photographic image, so a spreadsheet, and there's a highlight in green on that page, paragraph 26. And it says provincial, and it says region free state, it says African Alliance of Social Democrats, it says unrepresented, and then the question is, candidate /S captured, and it says yes. So the only outstanding thing was in effect the signatures, which is what I was saying when I said that is a failure that we submit, the commission had the power to rectify. If there was no list, then Justice Majid's case in terms of Liberal Party then would be applicable. However, in this case, it was simply the signatures.
So you would contend that this brings you within the ACDP case? Remember, in the ACDP case, they paid the deposit, but it was not allocated to the right channels.
Indeed so. So, Justice Matupu, when it comes to the issue of substantial compliance, I think this court itself said we need to follow a common sense approach of looking at the facts as they are, not necessarily what we think they ought to be. In this case, there was a submission of a list. There was the payments of all the other monies which were required. There was uploading of ID numbers, etc. The only outstanding issue is the issue of signatures. So let's use a mathematical precision to it. 3 out of 4 was satisfied. That puts us at 75% substantial compliance.
Well, it makes me think. But there is a big but there. Is it permissible that you, in terms of the rules and the regulations, that you have to comply that way? In other words, if I were to use the flight example, you are in the lobby at the airport, you've checked in and everything else, and then you don't go to the runway to board your flight, and it takes off. Are you going to say you're on that flight?
Justice Matupu, let me give you a better example. You are inside the IEC's offices. You have got your badge in your hand. You've handed one over, and then cut-off time arrives. They've accepted that one that you've handed over, 16:59:59. Cut-off time arrives. Where do you stand? My submission, Justice Matupu, is that you've substantially complied. Now, the example that you use about a flight, I could take it one better. Between the airplane and the last boarding gate is known as a chute. So if you are inside the chute and facing the door of the airplane, are you effectively inside the airplane? Can they leave you? No, they can't, because you're already inside the chute.
You know that causes me problems. and I'm speaking for myself. Perhaps let me leave it. Maybe my colleagues will take it.
Mr. Blegas,
Yes, Justice Mahlan.
still on the page that you had referred us to, para 28, 29, and 30, I'd like to read page 2 to 9 of your papers,
Yes, Justice.
where you showed us the table. Now 2 to 9.
Yes, indeed.
I'll read 28, 29, and 30. Maybe you can comment on that, just to clarify. At 28, you said it stated that while it uploaded sufficient supporters for multiple elections, it did not upload candidates for any of those except for the Free State provincial election. It therefore cannot compete in those elections. Is that correct? So,
That's correct.
so the only province, it will be the Free State province, but we're still going to go to the signature issue.
Indeed, sir.
Okay. Now 29, it then says, for the Free State election, although ASSD uploaded sufficient supporter information, it did not upload any supporters' signatures. And then it says section 27.2C, capital B, Roman figure 2, requires parties to submit the names, ID numbers, and signatures of voters. It therefore cannot compete in those elections. Do you want to comment on that?
Yes, I do. Thank you for that. It's on those reasons, Justice Infanta, that I indicated that the Liberal Party case, as as given to us by Justice Majibu was actually not appropriate in this case, because that one was quite specific to candidate list. Now, if you look at section 28, it says that where a party has submitted a candidate list, but has not fully complied. So there are two parts to that. And the question the court must ask is, did you submit a candidate list? Give words their ordinary meaning, yes. All right. But it also turns out that you were not fully compliant in terms of other avenues. Now, if candidate list is put to the side, this then becomes effectively a other failure, as was described in paragraph 22 of the Liberal Party case. This is what that other failure is. And so, in effect, that could have then been rectified on the 11th of March by the Commission when it dealt with issues around non-compliance with the submission of lists.
So for the Free State one, the list had been submitted.
Yes.
And what was outstanding?
It was signatures.
So the Commission would have to notify AFSD that it has not complied and it must comply.
That's exactly what my senior wanted to say.
That's what you say.
Indeed.
Now, the next paragraph, you then say it admits that it did not comply with the requirements of Section 27 in the prescribed manner, by the prescribed deadline for any election. That is why it seeks the opportunity to enable it to submit the outstanding candidate lists. Why now? Because you missed the deadline for the candidate list.
Justice Mhlanga, and this court has got all the powers to it in order to give us an equitable order. If this court finds that paragraph 30, which you've just read, is not in line with this court's thinking, this court must still consider whether it will grant us the relief insofar as the Free State is concerned. Because there, it is undisputed that there is a list, and the only outstanding thing is the signatures. So this court may well deviate from what's written and paragraph 30 is simply us saying, we realize that we were short, but our understanding of the rules and the Act were that Section 28 put a prerogative on the Commission to notify us. So if we don't make it through into the national elections, that's this court's prerogative. But insofar as us having satisfied the Free State's requirements, we are certainly saying that this court should consider allowing us to partake in that election.
Thank you.
Okay, let's just get this clear. You rely on Section 28 and you distinguish Liberal Party, right?
Pardon me, Justice Majibu?
You rely on Section 28 and you distinguish Liberal Party in respect of the Free State.
Indeed, sir.
Let's look at the Act. The Act says this, Section 28. Do you have it there?
I will open it now, Justice. Yes, Justice. Justice may proceed.
Let me go back to 27. 27CB, small c, capital B, deals with signatures, names, identity numbers of supporters. Do you accept that?
I do.
Do you accept that?
I do.
So 27CB, remember that. 28 reads thus. If a registered party that has submitted a list of candidates has not fully complied with, and I'm going to go slow, Section 27(2)A, B, C, capital A, D, or Section 27(4). All right. The chief electoral officer must notify that party of its non-compliance. 2. The notification must be given in the prescribed manner by not later than the relevant date stated in the election timetable and must indicate that the party has an opportunity to comply with, again, Section 27(2)A, B, C, capital A, D, or Section 27(4). You see 27CB is not there.
Pardon me?
27CB is not there.
Indeed, sir.
So?
Well, why we are then relying on 28(1) is because if we read the sentence carefully, it has a start part to it. It says, if a registered party has submitted a list of candidates, but then has a failure. So,
you see, it's very simple, Mr. Vilakazi. Liberal Party says, if you have submitted a list of candidates, but you've not fully complied with Section 27, then the legislature makes a specific list. Now, we know the principle, inclusio unius est exclusio alterius. It specifically omits 27 or 2CB. What must we make of that? That's the signatures and the names and the ID numbers.
Thank you for that, Justice Majid. Justice Majid, Liberal Party, paragraph 22, the last sentence reads as follows. The applicant had not submitted a list by the deadline. So, in my mind at least, that is different. Hence I've said, if these failures are, if the lack of signatures, but there being a list, is considered other failures, then certainly we are of the opinion that the Commission should have come to our rescue in that regard.
Mr. Vilakazi, here's the problem for you. The Liberal Party was decided in 2004.
Yes.
This thing of supporter signatures is a new thing.
Indeed, sir.
It came because of the One Movement South Africa judgment of this court, where the majority judgment said, in order for us to set some kind of threshold, we are going to set a threshold for a certain number of signatures that you must produce, names, identity numbers, and signatures, so that you can get through the gate, right?
Yes.
So when you read Liberal Party, you must read it subject to that caveat, that we are now dealing with a new phenomenon of signatures. And that is why I say to you now, as a matter of interest, if you look at the Act, it tells you that 27CB and the others that are new were introduced with effect from 19 June 2023 as a result of Section 3 of Act 1 of 2023. That's the Electoral Amendment Act. And then it pertinently says, as far as 28.1, where CB is excluded, it says the same thing, with effect from 19 June 2023, and it is by virtue of Section 4 of that same Electoral Amendment Act. So that is why you must read the Act now with a general principle of Liberal Party in mind, but bearing in mind that CB is expressly excluded from matters that can be rectified. You see the problem that I have?
I kind of see it, Justice Majid. If I can just refer you to one last part in order for me to complete my submissions on this specific aspect. If you go to page 31 of our bundle, paragraph 20, page 31, paragraph 20, it reads as follows. Providentially, the AASD has, however, fulfilled its requirement to obtain 13,931 valid signatures. And then it goes on to speak about where they are sitting. So it says signatures as well. And then it tells you where they are sitting. So it's sitting on the OCSN portal, as it were. I'm sorry, my laptop just switched off. So in effect, if the argument is accepted by the court that, pardon me, thank you. I do apologize. Yes, thank you. I'm just trying to find it. If the court accepts that we had gone as far as we could effectively before 5 o'clock, and we had followed the majority of these steps, then I would submit that in effect is where substantial compliance really comes into it.
See, Mr. Vilakazi, let me just say generally, in respect of all these cases, I think the aim with the Constitution, with the right to vote and the right to stand for office, is aimed at inclusion. I think the Constitution is aimed at, because we were denied, those of us who were of darker hue, were denied the right to vote. It's very, very particular, and somebody called it red rights, first generation rights. Constitution is very adamant about that. But having said that, there must be rules. The rules must be certain, and the rules must be adhered to by everybody. You can't make fish of the one and fowl of the other. And so, when I put all of this to you, I'm saying to you that much as we would like to help you, and I assure you the court would want to help you where we can, we are bound under the principle of legality by that which we can do, and that is the law. And if the section specifically excludes what you want us to do, then we can't do it. Because it's not a question of or, it's a question of 27 CB is very clear. You must submit in the prescribed manner the names, identity numbers, and signatures. Now, these are just allegations for now, but there are allegations already of forged signatures. Do you understand why these are important and why, if they are excluded for rectification, we must apply the law as it stands? We can't make up the law, we must apply the law.
I understand you, Justice Majid. Justice Majid, I can't take my submissions any further on that.
Yes, thank you. I think you've done very well, actually. Thank you.
Indebted.
We've reached the end of the road. Thank you, gentlemen. The court is indebted to you for your submissions.
My apologies, Chief
Oh,
Justice.
want to say goodbye to the cherry?
No, bite to the cherry. I omitted to answer a question of yours about costs. I said I'd take instructions. I have taken instructions. We do seek costs.
All right.
Thank you.
So, Deputy Chief Justice, I do seek one bite at the cherry because this argument that was raised now by Mr. Vilakazi is really a new argument that was not advanced previously anywhere, this argument that there was compliance just for the Free State. And I'd just like 1 minute just to address it, if I may.
Yeah. Okay.
So it just builds on what Justice Majid put to Mr. Vilakazi. And if one looks at section 27.2, so 27.1 requires the registered party who wishes to contest an election to submit a list or lists. And then 27.2 says the list or lists must be accompanied by various things. CB we know is the names and signatures, and that also asks the court to look at E, which is the deposit. And those are the two that are not in 28.1, the signatures, supporters information, and the deposit. So those are the two that cannot be remedied if they're not met by the deadline. What can be remedied is A, which is undertakings, declarations, and so on, signed by the candidates. So it very specifically determines what can be rectified after the date and what cannot. And it's important to be clear about what the consequence of Mr. Vilakazi's argument would be. It would be that every single unrepresented party did not have to submit signatures by the deadline. It could have submitted no signatures, and the Electoral Commission was obliged for all those parties to afford them an additional opportunity under Section 28 to comply. If parties had known that, I think they might have managed their uploading very differently. But they didn't read it that way because that's just not what the section says. It doesn't permit rectification of signatures or non-payment of deposits for good reason. And so that's why, unfortunately, the ASD, even though it had a candidate for the Free State provincial election, didn't have any signatures. And so it can't be a question of substantial compliance. It's not, well, I complied with 3 out of 4 requirements. If there are 4 requirements and you didn't meet 4, you haven't complied. It's not about substance or not, you just haven't complied. Thank you. That's my only submission, Deputy Chief Justice.
All right, thank you, Mr. Bishop. Judgment is reserved, and perhaps just to, sorry. Mr. Loxton, you see this ad hoc manner of doing things. You made a submission about costs. Mm-hmm. Do you have anything to say to that, Mr. Bishop?
No, I heard Mr. Bishop. I heard Mr. Bishop, and I heard him mention that there are conflicting decisions about whether or not to award costs against the Commission. Mm. And in this case, my instructions are to award those costs because, in effect, we've put up a case against the Commission, and we find out at a very late stage that there is material information which we didn't have before. So we're persisting with that with that costs order. We understand that this court is at liberty, given the Commission's duties, and I understand the argument that when a regulatory body performs its duties, if it doesn't act mala fide, the court will often not award costs. I take that into account, but my instructions remain the same.
Okay.
Thank
Thank
you.
you. That is everything. Okay. Judgment is reserved. And as I was saying, perhaps just to reassure the parties, we are acutely aware of the agency surrounding the matters and the looming deadline of 17 May. So, corrections.